Good morning, friends. Weather is very cool and there is poor visibility. So, while driving, please take care. After taking green tea, I am fully settled. So, I am diving into another topic on SLP. The topic is when you withdraw your SLP, and the Honorable Court does not give any comments while your SLP is dismissed as withdrawn, then can you file SLP on the same facts or not? This is the question which I am going to discuss with your all good personalities who are aspiring for, preparing for advocate on record examination. As there are short questions too in the advocate on examination, which you should keep in mind while preparing for the advocate on record examination. Friends, in legal terms, a second special leave petition, shortly SLP, refers to a request made to the Supreme Court for permission to appeal against a lower court decision after a previous SLP has already been dismissed. Generally, the maintenance of second SLP without liberty being granted, that is, permission to file another petition, is a complex issue and is governed by the principles of judicial discipline, finality of decisions, and court's inherent powers. So, the general rule for SLPs, according to the Supreme Court's practices and procedure, when a SLP is dismissed, the court may either do so with or without liberty to approach the court again in the future. If the SLP is dismissed with liberty, the party can file another petition based on new grounds or fresh circumstances. However, if the SLP is dismissed without liberty, it means the court does not wish to entertain the matter further. So, coming to maintainability of second SLP, if the maintenance of second SLP without liberty being granted typically hinges on whether new facts or legal issues are involved that could justify a fresh hearing. If the grounds for the second SLP are already, sorry for disturbance, if the grounds for the second SLP are essentially the same as those in the first petition, the Supreme Court is less likely to entertain it. A second SLP would generally not be maintainable unless there is a clearer error or misinterpretation in the first order that justifies the reopening of the matter. This ensures that the finality of judgment is respected. Now, coming to relevant case laws, first one is state of Maharashtra and state Suresh, that is case of 2000, volume 1, Supreme Court cases 412. In this case, Honorable Supreme Court emphasized that once an SLP has been dismissed without liberty to file a second petition, the court would not entertain a second SLP unless there is a significant new development or compelling legal reasons to do so. This ensures respect to the finality of the judgments. Then coming to important case law, that is Rupa Ashok Khura versus Ashok Khura, 2002, Volume 4, Supreme Court Cases, page 388. In this case, the court held that while the judicial discipline requires that once a matter has been disposed of, it should not be reopened lightly. It further clarified that after filing of that the filing of successive petitions without permission could lead to abuse of judicial processes. Now, there is another case, Pritam Singh versus State of Punjab, 1992, Volume 3, Supreme Court Cases at page 243. Honorable Supreme Court reiterated that when an SLP has been dismissed, it represents the final decision unless there is manifest error or extraordinary circumstances. The court discouraged the filing of subsequent petitions on the same ground without liberty. So this is all about the situations where the question arises whether the SLP again be admitted or not. Thank you for watching. Take care. As the weather is there is very cold outside, and visibility too is low. I fear for all of you, so avoid going. If you are in emergency to go, then go at a slow speed. That's all. God bless you all. See you again.